Hey everybody, good morning. I'm JD Hovener, owner, founder, and patent attorney here at Bold Patents Law Firm. I've helped many inventors over my 10 plus years doing this here, being a patent attorney, and happy to do this video here with the topic, of course, being design patents versus utility patents. Which ones should you pick? Let's jump into this right away. Design patents are those that are issued that cover just the three-dimensional shape of an article of manufacture. These are generally easier to get because the claim scope can be quite specific and narrow. Design patents cover just that one shape that you draw out. The patent drawings have to follow very specific guidelines. And while we'll get into the details of those drawings, that's the heart of the invention. And really, there's very, very few words that you're able to describe your invention with. What you actually own are the black solid lines, sometimes shading, that are within the drawings and the figures. Whereas the utility patent can be much more difficult to achieve, but worth the journey. You get 20 years of protection versus a design patent of only 15 years. With a utility patent, you actually get protection on the functionality. You own what it does. And in essence, that's what's novel, is in the utility patent, you decide, hey, what's my functionality? What's my utility? The benefit here to humans, to anyone, right? Any person, machine, process, or method, that's what you're going to write out. And it's the written English words called claims. That's what you end up owning with a utility patent. Versus on the design side, remember, we had drawings and just the visual aesthetic. That's what is owned under design patents. Utility patent, you get a lot more breadth and can own perhaps a bit more when you get to use words. Now, it's the good with the bad, right? The good thing about utility patents can be that they're generally higher value if you can secure a granted patent covering a novel functional benefit. But the essence of them being litigated, right, can be fraught with a lot of issues, right? Defining each word of the utility patent, having to painstakingly look through the alleged infringer to see if they're meeting every element of those claims, versus the ease and simplicity of looking at the design, the 3D shape. An ordinary observer, that's the actual test that's used in patent law for design patents, is, hey, is the infringing article, would it have been mistaken for the patented design? I mean, are they close? Is it similar? That's really the extent of the evaluation. And so it can be a lot simpler to enforce a design patent. What's great is that you aren't limited to just one or the other. If you've got a physical product, it's almost always a benefit to go for both. That's right, seek both patents for design and utility covering that one invention. That way you're protected for both having a broad, nice scope to prevent competitors from easily designing around your invention, while also having the belt and suspenders, being able to enforce your patent relatively straightforwardly with a design patent as well. So those are the quick high-level differences between design and utility patents. There's a lot more detail here, and if you have questions, please do submit them. Contact us at boldip, boldpatents.com. Submit your contact information and book a free discovery call if you're ready to move forward with your invention. Again, I'm JD Hovener, patent attorney, founder here at Bold Patents Law Firm, wishing you a great day. Go big, go bold.